Look, ultimately, when you're talking about taking a council to the court, you are thinking about what you can do with the land, and council is not at terms of, you doing a development. Now, this could be an underdevelopment or an overdevelopment. It could be either or, right? And so, for example, you want to put, 5 townhouses on the land, and council only wants to put 2 or 3. And of course, your numbers are not working. And so you're quite emotionally driven from a profit point of view, right? And council is thinking more from a neighborhood character, from protecting the suburb, protecting the trees, etc., all of those things. And so when you do a breakup with the council as to, okay, the council is not listening, or they are about to, grant a refusal letter, not grant a refusal letter, they've actually refused or granted a decision of refusal of a development approval, that is where an option opens up where you can lodge in a complaint or lodge in a case against the council in a tribunal, contesting the decision that the council has made. And that's the first place where you would usually start. And you're right, it's not very common. It's very, very common in Victoria, where a lot of developers have to explore that opportunity, where a council might have said yes to them in the pre-meeting, but, as you've put up the plans, they might say, look, this doesn't work, and, this is not the path that we want to go down. And so it's very, very common, and it's very time consuming, and it's very emotionally draining as well. A lot of developers get scared of going to VCAT. And so naturally, what a developer would do with the first instance is just sell the site and move on, right? And so, they would sell it at a loss, or they would sell it at, thinking that, okay, this is the end of it. And there are only a handful or a few who are brave enough to basically go into a tribunal to get this done. And again, I say this brave enough is because you are dealing with an authority. You are going against an authority, against the council. And so there could be a lot of retribution. There could be a lot of fighting, just not with the council, but also with the neighbors as well, because, they might be there taking you to VCAT. So there are various different reasons a lot of this happens.
Yeah. And I can just on that point, because it's such a, and I don't know what the statutory period is that you need to go through the council before you apply to VCAT. Is there one? I know in New South Wales, it has to pass or surpass a certain time before you can take it to the tribunal. So is there a similar sort of requirement here in Victoria?
Definitely there is. And so another thing to consider is getting an external or an experienced town planner, and to assess the application in its own independence, in its own merits. A lot of the time people have their own town planners when they're going in to represent even to the council, right? But those town planners may be playing on your side. They might not be playing on an independent side, right? So it's important to get that feedback from a third person saying, hey, can you assess this case and look at the merits of what the council is saying versus look at the merits as to what we are saying. And without taking any sides, can you provide us an honest opinion whether this works, right? And usually these town planners are from local councils. We've worked within these councils before, or have a lot of experience, in VCAT, etc. So it's always important to get that view of the world. That town planner would also give you guidance, ensuring that you're following the residential code to a T. Now, it's not just about the residential code, but there are also council rules, that supersedes the residential code or the res code as well. And so, particular councils might have their own regulations or precincts, what they call it, in place. And so you need to consider some of those things as well. And that town planner would assist you. Also, the important thing is that you need to look at what your worst case scenario happens. And so what if you lose? What if you don't get what you are asking for? Because VCAT is not a place to negotiate. There is no negotiation at VCAT. VCAT is all about, I'm wanting this, and can I get this? And they'll say, yes, you can get it, or no, you cannot get it, right? It's not so much about, hey, you cannot get this, but maybe you can try this and we'll approve this. That's not how VCAT operates. VCAT operates on a very yes and no basis, right? And so there is no negotiation per se. There is one step where negotiations do take place, and we'll talk about that, which is the compulsory conference, as we go through the case. And so understanding your worst case scenario is always very important, okay? And so based on the worst case scenario, you need to understand what is your best case scenario as well. And what do you want to put it forward? And how do you go around navigating through some of these things? And we'll talk about this when we discuss my own case of, the most recent VCAT application that, we won through. And so again, you don't get multiple opportunities at Tribunal. It's not so much about, hey, I'm going to try this, and then I'm going to try this plan, and I'm going to try this. That doesn't work. If VCAT says no, then your natural point of going forward is going to the Supreme Court, and that's where it basically goes.